Hi, my name is Shaye Larkin. I'm a San Francisco bankruptcy and tenant rights attorney, and one of the services I provide to my clients on a regular basis is I help tenants get their security deposit back from the landlord after they've moved out and the landlord has taken the deposit illegally. This video is based on California law, and watching this video is not a substitute for sitting down with your own attorney and getting specific advice about your specific situation. Now, one of the areas of security deposit law where I see landlords making mistakes most frequently is in the area of the disposition of the security deposit. California Civil Code Section 1950.5 requires that within 21 days of when the tenant has moved out of the property, but not earlier than the date that either the tenant or the landlord have given their notice of intention to terminate the tenancy, and not earlier than 60 days prior to the expiration of a fixed-term lease, the landlord shall furnish the tenant with a copy of an itemized statement that specifies the amount of the security deposit and the basis for any deductions, along with payment of the remaining security deposit. The disposition of the security deposit must be mailed to the tenant at the forwarding address provided by the tenant or to their last known address if no forwarding address is provided. Now, the last known address of the tenant may very well be the apartment that they have just moved out of, so if they have not forwarded their mail to their new address, then it's quite possible they will not receive the security deposit. If the tenant paid the deposit or their rent by electronic means, then it's perfectly okay for the landlord to refund the security deposit in the same manner or any other method that is agreed to by the tenant. The statement of disposition of the security deposit can be emailed to the tenant instead of sent by regular mail, so long as the tenant has agreed to this method of delivery. In addition to the itemized statement, if the landlord is charging for repairs or cleaning, then they must also provide supporting documentation. If the landlord's employee performed the work for which the departing tenant is now being charged, then the landlord must provide documentation showing the breakdown of hours spent and the hourly rate being charged, along with receipts for any materials purchased. If the person or company who did the work is not the landlord's employee, then the landlord must provide a copy of the worker's invoice, bill, or receipt supporting the charges. If deductions are made for repairs or cleaning, then the landlord is required to provide the tenant with photographs taken both when the tenant moved out and when the repairs and cleaning have taken place. If the tenancy began on or after July 1st, 2025, then the landlord must also provide photographs that were taken immediately before or at the inception of the tenancy. If a repair cannot reasonably be completed within 21 days after the tenant has moved out, or if the supporting documentation is not in the landlord's possession within 21 days of when the tenant has moved out, then the landlord may deduct the amount of a good faith estimate of the charges that will be incurred and provide that estimate in the itemized statement. The landlord who is claiming the supporting documentation is not in their possession must provide the name, address, and phone number of the person or entity completing the repairs who is in possession of the documents. Within 14 calendar days of completing the repairs or receiving the documentation, the landlord must complete the requirements of issuing the final statement of security deposit with the required supporting documentation and issue any remaining refund that is due. If the total cost of repairs or cleaning to be deducted from the security deposit is less than $125, then the landlord does not have to provide supporting documentation for the charges. The landlord is only allowed to deduct from the security deposit for compensation of the tenant's default in rent, the cost of necessary repairs exclusive of ordinary wear and tear that were caused by the tenant or their guest, the cost of cleaning the premises in the amount necessary to return the unit to the same level of cleanliness as it was at the inception of the tenancy, and to remedy future defaults by the tenant in any obligation under the rental agreement to restore, replace, or return personal property or appurtenances, that means fixtures, exclusive of ordinary wear and tear, so long as the security deposit is authorized to be applied in this way by the rental agreement. California Civil Code Section 1950.5M provides for a bad faith penalty of up to 2 times the amount of the security deposit in cases where the landlord has wrongfully withheld the security deposit. So this is a strong deterrent that will hopefully make sure the landlord does things the right way. The burden is on the landlord to establish the reasonableness of the deductions from the security deposit. All right, that is the disposition of security deposit. I'm Shaye Larkin. Thanks for watching.